Hello, everyone. All the trainees of the EDPS and EDPB, welcome you to this conference. We're very happy to have you here, those that are on site with us and those that are online, and we thank you for your participation. My name is Spiros Fondalis. I am a trainee of the EDPS at the Technology and Privacy Unit, and I will be the moderator of the following panel discussion. The discussion aims to offer an overview of how the recent advancement on AI impact data protection. More specifically, some themes that are going to be explored are the risks of AI on fundamental rights and data protection, the balance between data protection and AI innovation, and the contemporary role of the EDPS. Since our audience today is mostly comprised of trainees and generally people that have no expertise in data protection or AI, we will try to keep the conversation at high-level principles so that everybody can follow it and have meaningful takeaways. The event will hold 2 keynote speeches, the main panel discussion with about 45 minutes, a Q&A session, and then the closing remarks. It is with great pleasure to welcome our distinguished panel of guests. Welcome, Vincenzo. Welcome, Stefano. And welcome, Vangelis, our online speaker. And of course, welcome, Leonardo. And Isabel. Before we start with the first keynote speech, let me acknowledge our regret for the lack of gender balance at the podium. We would certainly love to hear a female expert's opinion, but unfortunately some high-level female experts were unable to attend last minute, and we have not been able to make up for this due to time sensitivity. Let's move forward to our first keynote speech. Let me welcome the Secretary General of the EDPS in charge of the EDPS Secretariat, Leonardo Cervera Navas. Leonardo has been working in data protection in the EU institutions since 1999, and in 2010, he joined EDPS as head of HR, budget, and administration. In 2018, he has appointed director responsible for coordination and implementation of the strategies and policies of the institution. Leonardo, please. It's yours.
Now, someone had to unmute me. So, good morning, everyone, or good afternoon, depending whether you have a Mediterranean schedule or Nordic schedule. For me, it's still good morning. First of all, apologies for not being able to be there. I had some family commitments, and family always comes first. But I'm very happy to be able to address you with the help of technology. And first of all, I would like to welcome all the trainees of the EU institutions and bodies who have come to our invitation to talk about data protection and AI. You are today trainees, but in the future, you will be the policymakers and the forces of the EU. I'm pretty sure of that. So thank you so much for getting involved and for helping us to increase awareness about this topic. Also, many thanks to the trainees of the EDPS and the EDPB who have made possible this event. Let me mention them in their name because they deserve credit. So thank you to Jaume Murisco, Gabriela Stionova, Ángeles Madueño, Renata Dorina, Angelica Ricci, Marinela Ceremet, Inés Fernández Gallego, Spiros Fontalis, who just spoke, Ela Gersmuskova, and Matilde Leon. Thank you very much, dear colleagues, not only for organizing this conference, but most importantly for helping out so much with in the work of the EDPS and the EDPB. Thank you so much as well to our speakers, Vincenzo, Vangelis, Stefano, and of course, Brando Benifei and Isabel Bereken. We are really looking forward to hearing your views about these topics. And allow me just a couple of minutes to tell you a little bit about the work that we do at the EDPS. I guess for the EDPB, Isabel Bereken later today will say a few words. The EDPB is both, the EDPS is both Data Protection Authority and EU institution. So our mission is to be a data protection authority of institutions and bodies, to provide policy advice to the legislator. So every time there is a proposal with a data protection angle, the Commission is supposed to seek our views. We are, from the EDPS, mandated by the legislator to closely monitor technological developments and the impact that new technologies may have on data protection and privacy and our society in general. And we also have the duty to provide the Secretariat for the European Data Protection Board. At the end of the day, our main mission is promoting a strong data protection culture in the EU institutions, so we can lead as an example as EU administration, and we can make sure that we adopt EU legislation with a high level of data protection. At this moment, we are very excited about the new competences that we will get on the issue of AI. So in the AI draft, we are called to be the AI regulator for EU institutions and bodies. To tell you the truth, at this point, we have more. Sorry, I need to close this. So to tell you the truth, at this moment, we have more questions than answers. So we have a lot of work to do, and these kind of events are really helpful to understand what are the real issues and how to tackle them. But in any case, we are very excited. We are fascinated about this opportunity that we get to regulate something new, fresh, and to get it right from the beginning. We will need to make sure that the regulation on artificial intelligence, the regulation on artificial intelligence and the GDPR go hand in hand for the benefit of everybody. We need to embrace technology on the basis of EU values. We need to have regulation that is flexible, adaptable, but with a strong enforcement. So not to stiffen innovation, but at the same time being able to kick out immediately from the EU any bad uses of this technology. But first, we need to pass the AI Act quickly so we can replicate the Brussels effect that we achieve with the GDPR. We are not far from this. With goodwill and the hard work of everybody, I think we will be able to have this law passed very soon. So to help with this objective, the EDPS is very active. This conference is just an example of it. We are working very hard to help with this process, and we will be publishing an opinion on this matter very soon, probably even next week. So stay tuned. I hope that you have fun with today's conference, and I give back the floor to Spiros.
Thank you, Leonardo, for that speech and that interesting introduction to the work of the EDPS on the AI Act. Let us move to the main panel. We have actually an agenda change of last minute. Our second keynote speech was about to happen now, but it will happen at 1 o'clock later, probably after the panel discussion. So it's with great pleasure I come to introduce our panelists today. Let me start with Vincenzo Tiani. Vincenzo Tiani's work focuses on privacy and personal data protection, intellectual property, and the protection of digital fundamental rights. He combines experience working for the European Parliament, carrying out legal advisor responsibilities, and also working for NGOs on matters related to fundamental rights. Additionally, he writes relevant articles in various publications and holds a podcast in which he delves into issues related to new technology, law, along with distinguished guests. Vincenzo, one quick question for you so that we break the ice with the audience. So I need an answer in 20 seconds if you can. Who was the podcast speaker you learned the most from? And why, if you can answer this?
Can you hear me? Yes? Okay. Speaker, I would say that I would mention the two podcasts that I listen every week. still for years. One is the Vergecast from The Verge. I don't know if you know him. If you know it, it's an American publication. And the other one I really appreciate is the Hard Fork from the New York Times. And I think, especially in the latest discussion on AI, I think they found a very interesting points of view. Of course, even I don't want to not mention European podcast. I also listen. I'm a listener of a Euractiv podcast from Luca Bertuzzi.
Thank you so much. We move forward to Stefano Leucci. Stefano Leucci has studies related both to the law and computer science. He's a legal and technological expert at the EDPS. His main responsibilities concern strategic foresight of new technological trends, financial issues, and artificial intelligence. Stefano has a diversified experience as a data protection officer, both in public and in private organizations. The same quick questions for you. What is the most satisfying gain for you of working in the public, as a public servant?
Good point, good question. Well, I think the possibility to be at the core of the policy making and participating in the discussion, taking out my ideas, putting them on the table, discussing with high-level colleagues, people, and not only here in Brussels but everywhere, no? in Europe and the other data protection authorities, and also to see things coming first, because at the end Brussels and the data protection bubble is here in Brussels, is where things happen the most.
Thank you so much. We move forward with our last speaker, who is online, Vangelis Papakonstantinou. Vangelis has carried meaningful work in the academic, private, and public policy sectors. He's a professor on personal data protection law at the Faculty of Law and Criminology at the VUB, the Free University of Brussels. Also, he has participated in a variety of EU-funded research projects and has participated in lawmaking committees for the release of all major EU and Council law and regulations on personal data protection, including the GDPR. In addition, Vangelis practices business law with emphasis on technological startups and mid-sized companies through MP Legal, a technology law firm in Athens and Brussels. Vangelis, quick question for you. You have covered almost all aspects of work, public, academic, and private. Is there any other diverse jump you plan for your career, mid or long term?
Thank you, Spiro. Okay, now. Thank you, Spiro. Hello, everybody. I apologize too that I cannot be there. I'm in an academic visit these days in Florence. Not, of course, that I will complain about being in Florence and the excellent location of VUI, but still, it would have been very nice to be there with you for this conference. Regarding career moves, that I cannot tell. What I can tell is that moving out of academia from time to time is challenging and rewarding, but at times also exhausting. So if I am to make a choice, which I think I will in the foreseeable future, is to return and stay for sure within academic limits. So thanks, Spiro.
Thanks so much. So we move on to the main part of the panel discussion and to our questions towards our speakers. Vincenzo, you're first. Let's start with an introductory question so that our non-specialized audience can get somehow into context. Recent leaps and significant advances on the AI scientific field have rendered AI a really powerful tool. As any tool, it can be incredibly beneficial if used properly or generate dangers and risks if not. Please tell us, what specific risks does AI pose to the rights and freedoms of individuals, and especially vulnerable groups, such as minorities, for example? Thank you.
Thank you for the question. Can you hear me? Yes. So perhaps before, how many minutes I have? 5, 6?
5.
5, okay. Explain AI in 5 minutes.
We will not bite you.
Just kick me, if you want to kick me.
With pleasure.
Thank you. Thank you, Stefano. So for the ones that are here because a friend of a friend told me, yeah, you should come, just a quick introduction to the AI Act. So we have the European Commission decided to provide, let's say, to have a risk approach. So we have 4, let's say, levels of risk: unacceptable risk, high risk, limited risk, and no risk. So Of course, the main issue that we can find are with unacceptable risk and high risk. Unacceptable risk, for example, we can find social scoring. I don't know how many of you have ever seen, Black Mirror. There is a specific episode, I think, in season 3 or season 4, called Nosadin, I think, where basically, people are in not so far future, like, it could be 2030 or 2026, where basically you go to the bar, you order something, and then you rate whatever interactions you have with anyone. And the fun thing of Black Mirror is that the authors of Black Mirror said, we created a series to say, okay, as a warning, not as an inspiration. And actually, this is the thing. There are some countries in the world where this is real, okay? So since we are, thank God, personally, in Europe, we have a different approach. We think, perhaps sometimes we think about risk too much, but we don't want to avoid that kind of questions. So social scoring is one thing, and I'm happy that both, Brando for sure will tell you more, but the Council, the Commission, and the Parliament all agree on the fact that social scoring should be banned, okay? Real-time remote biometric identification systems. This is another very crucial issue here. You think you go to a public square for a political event. For security reason, you could be, let's say, recognized in real time. So I go to a square. I'm not doing anything bad, but police could know that Vincenzo Tiani was there. Okay. I don't know how many of you would like to live in that kind of world. Please, most of you are trainees from EDPS and EDPB, so don't say, yeah, but I have anything to hide, so what's the problem, okay? I hope nobody will never answer that kind of question. My dad can, my mom can, because they are my benchmark. I try to understand with my parents what the general audience think about these kind of issues. And I think this kind of discussion we should have not just in the European Parliament, not just on this kind of great events, but really with our friends. And again, I'm very happy that the European Parliament, in the version of the European Parliament, this kind of real-time identification, even if it comes from the police. I mean, of course, we should trust police, but we know that once any authority, could be the police, could be a government, as new power that is not well counterbalanced by rights, then we know what can happen. And it happens even in Europe, okay? We're not talking about far country, far away. It's really, sometimes it's an European issue. So I know that kind of discussion will happen during the trilogue. Then we have high risk. So high risk, it's not unacceptable, but still, could have serious consequences for data subjects. So general, not real time, but biometric identification and categorization is an issue, of course. Why is that? First of all, because we know it doesn't work very well, and there could be bias. And also because perhaps we don't want to be categorized. And every time, the problem that technology poses, and I'm going to finish, you want to kick me, the problem that technology poses, this kind of technology, compared to a phone, is that any automated decision, and we know from Article 22 of GDPR that already provides some guidelines, some safeguards, basically it's hard to control, okay? So every time I cannot access any building because the system say that you cannot. Every time you are young now, but in a few years you will apply for a mortgage to the bank because you want to buy a house, and every time we will start from something on a screen. Okay, you will not talk to someone. It could happen later, but you will start with your screen. What is your salary? Are you married or not? You have children or not? And then you will receive yes or no. Okay, and you don't know why. You should know why, because GDPR says that you should have explanation, blah, blah, blah. But this is what happens with, let's say, basic technologies, and with AI will be worse. I don't want to, okay, I'm not against AI, of course, but here we are to discuss, technology, consequences, and data protection. So just a reminder, I'm not against innovation or AI or whatever.
Thanks for that. Thanks for that introduction to the risks of AI. Let's move to our next question. To you, Stefano. You have been working as a legal and technology officer at the EDPS for almost 3 years now. This means you have experienced the latest consequential stages of the recent AI and natural language processing revolution as a member of the EDPS. How have the recent developments in the AI industry shaped your work as a civil servant at the EDPS?
Thank you, Spiros, for the question. I think that our work has been shaped in two main ways. Leonardo, our Secretary General, before explained what we do at the EDPS. In particular, what we do in our unit, where Spiros is also contributing, is technology monitoring. So between all the other aspects that are also important, let me stay 1 second on this point. The technology monitoring seems a quite simple thing. Actually, it's a very complex one, but because of mainly the resource scarcity. Imagine how many technologies are coming out today with many different privacy risks to monitor, as Vincenzo was saying before. And we are just few people. So how can we be capable of monitoring and be experts on those technologies in so small time in such a deep manner? Was the big question that we had. And one of the way that AI helped us was to try to use AI to collect information, to gather the information that we need for becoming experts in this technology monitoring process through a sort of a very simple AI tool that is available on our website and you can go and explore. The idea is this tool is that collecting information from 3 big sources of data that are the European projects, the patents that have been published in the official the patent journal, and the scientific academic publications. AI tool, machine learning tool, was able to make order, select information from us, create a network of information that we can query and know, for example, which is the most important or the 3 most important paper that we need to read in order to get up to speed easily and faster. Because, otherwise, if you have in front of you an application that is working and that you don't absolutely know, you just go blind and in the dark. So this is to give another side of the story on what Vincenzo was saying. To me, this is a positive effect that AI had in our work. I think that another way was more oriented in the legal side of the coin, and was the ability and possibility to explore and find new ways to detect risks that can emerge from AI. Let me maybe on this go back to the law. I had a professor saying, read the law first, and AI somehow it's already in scope of the GDPR, because Article 22, by the way, Vincenzo was already mentioned this, says that the data subject shall have the right not to be subject to a decision based solely on automated processing, which produces legal effects or similar effects. So this is a very static legal definition, but here I think that we started to explore a lot more how a person can be affected by an automated decision-making process, and also which risk it might produce. To me here, the step to do is continuing, and is also about moving from a risk that is limited to something happening in the technology. For example, this technology has not a data retention process in place. It's not deleting data after a certain amount of time, but it's also about imagining the effect of such processing activity. So what happens if the technology is not deleting data? For example, what happens if a decision-making process that is automated is taking on data that are very old that cannot be used for produce a meaningful decision or a right decision on the data subject. So just to conclude, I think that those are the two important aspects that shaped and will shape our work. Back to you, Spiros.
Thank you, Stefano, for that insight on your work in the technology and privacy unit and how the EDPS as a whole handles this whole AI development. Vagelis, this question next is for you. The EU is currently discussing how to regulate the use of AI and steer it in more ethical pathways. However, compared to other major economic and geostrategical players like the US, the UK, or China, Europe's planned regulation is more strict and more restricting. The question to you is, might we be hindering innovation too much through this approach?
Thank you, Spiro, for this question. And I think I'm going to use to continue as Stefano started with study the law first. And this being also a trainees event, I would recommend to everybody to move a step back in order to properly address this question and put it in context. Because if we go back even in the 70s, when we had the first data protection instruments in Europe, it was the very same argument. It was the very same argument that personal data protection will hinder innovation, will be an obstacle to the development of information technology industry, etc., etc. And it has been the same discussion since. The technology changed, but not the main argument. We've seen it also before the release of the 5-year-long negotiation that led to the GDPR. Again, same argument that regulation will stifle innovation. And yeah, if we are to see this from the distance and we could somehow distinguish in a very broad manner and maybe arbitrary too, we would say that us Europeans are pro-regulation and perhaps our American friends are mostly against, as at least revealed through the privacy and data protection regulation. So after, I don't know, after 50 years or something, the truth is, the fact is that, as Leonardo said, the GDPR has developed a Brussels effect. So data protection prevailed from a legal point of view. But at the same time, what we are living in is a US-dominated technology environment. All online platforms that we are working on today are US headquartered. Therefore, there is this balancing between regulation and innovation that needs to be struck. It is always an argument, and it is always a disagreement between the two. And over the years, Europe has always opted for regulation, whether it strikes the correct balance between not stifling the industry, not suffocating it, and at the same time retaining its values and principles, it remains to be seen. As a side remark, I would point everybody's attention to the regulatory sandbox. There is a relevant provision in the AI Act that shows that even in Europe, we are now discussing about innovation and how better to promote and help it flourish. So yeah, the floor is back to you, Spiro. Thanks.
Thank you so much for that insight. Stefano, the next question is for you. It's a question that requires a bit of projection and the use of your imagination. The AI industry has proven its speed and unpredictability with its recent advancement. It is very possible that in 3 or 5 or 10 years, we collectively will experience rule-changing advancements again. What future AI developments and applications can you imagine that could pose significant risks to individuals?
Well, such a difficult question to answer.
I warned you.
I know. But I think that the first and really most important point is what, again, sorry, but Vincenzo again mentioned before, it's the mass collection of biometric data for surveillance purposes. To me, this is literally scary. We have, starting from very far, we've seen many situations where these things went too much against individuals. against the rights and freedom of data subjects. Again, here I think that that's exactly as we were saying before. Any one of us feel a bit unsafe when thinking about being monitored continuously in public spaces, when passing here in front of the European Parliament, for example, or going to the Grand Place and so on. No? But imagine doing more with this data, collecting those data, and then linking them, I don't know, to financial transactions, for example, even to biometric data that you are asked to provide to subscribe, but even to use every day your bank account. So to me, those things are quite scary, even when it comes to Europe, because some applications are already there, but luckily, I think they are somehow under control. A lot still need to be done. There's a huge discussion going on, but I have in mind a specific use case that happened in the south of France, where the Data Protection Authority worked together with the local police to address the use of such technologies, and its use has been minimized a lot, thanks to the action of the authorities. No. Because as you can imagine, those technologies are absolutely efficient, are probably the most efficient technology ever, but has biases. They make errors. So imagine you being at Rock Vector, no? The concert that has been last weekend in Leuven, and imagine being taken by a policeman saying, our biometric tool has identified you as a terrorist. So that's the effect, no, on the person. The fact that you will have these very unpleasant moments, and maybe you will get free, but the problem is that you have to follow this very bad moment and procedure also. And let me also mention the elephant in the room, because we need to do it. Also, the generative AI landscape. It's something that, again, not against innovation from my side. I think it's a great tool, and it's providing a very good help in many things that we do in our daily life. But on the other side, I think we can already see the effect of what might come out, like standardization, the average information that is spread to everyone. It's something that I think will come, so we need to address it now to be able to be right on time when the things will move from something that is unfolding to something that is widely used for real. No? And yeah, those are my two predictions. Thank you, Spiros.
Thank you, Stefano. Vincenzo, we jump to you. We will make a jump a little more deeper into data protection this time. Why does AI pose a unique challenge to data protection and the GDPR? What are the differences from other digital technologies?
Thank you. So, first of all, as Vangelis mentioned, GDPR has been always seen actually as an obstacle to innovation, as bureaucracy, basically, paperwork that nobody wants to do. And it's still the case after 5 years. So, of course, for the ones that want to innovate and want to jump themselves in the AI revolution, that's another challenge, because the AI Act will add something, but we should not forget that it's AI. The GDPR applies it, of course, to the AI as well. AI is not regulated just by the AI Act. The main challenge would be that. I work in a law firm as well, and we have many different clients, different business models, different businesses. And I can tell you, it's not easy, even with normal a normal business model, to comply with the GDPR. I'll make you an example. So you see, there is my tag of my name, right? You think, okay, it's okay. It stands by itself. Now, there's a trick, because it couldn't stand itself, so we put some additional paper, otherwise it would fall. That's how GDPR compliance works. Because sometimes you don't know. It's not the problem of the data controller. Because sometimes, you have the law. The law on purpose is wide. It doesn't say you have to do this, you have to do that. This is the list. It says, we have some principles, and you have to reach a goal. But even the DPA don't tell you need to do this before. You do your best and you hope for the best. So sometimes you don't know what is the legal basis. You think it's one, but perhaps you find out it's another one, and so on. So this is for normal businesses. Imagine with AI. One thing I really appreciate of the GDPR is transparency. You know, the data subject needs to know how his data, her data are used, are processed. And again, it's not always easy. But with AI, even the data controller doesn't know always how to answer that question, because I think you have a basic idea of how it works. So we have the phase with the machine learning. So you put there tons and tons of data, and then after a while, after having scanned 3 million of images of a cat, finally the AI say, okay, that's a cat, it's not a dog. I'm saying very simple level. Let's say it works like that. If sometimes it says, this is a cat, and you see it's a horse, you don't know why the machine says it's a horse. So sometimes you don't know as a data controller what to put, how to comply with the GDPR itself, because you don't know, you don't have the answer. So that for sure would be one challenge. You need, of course, to provide safeguards. We mentioned several times the Article 22. We will need more safeguards. And AI Act, thank God, I hope that the fundamental rights impact assessment of Article 29A suggested by the Parliament will pass. But that's another thing. We use the DPIA. Again, you will work a lot with the DPIA for sure, with AI. I hope there will be even a fundamental rights impact assessment. But again, doing data protection impact assessment is not something you can find a template on Google and then check. It doesn't work like that, of course. Then of course we need to keep the human in the loop, and we need to find why, because we need to really counterbalance the fact that there is no actual and profound transparency. But again, not because the data controller doesn't want to have this kind of transparency. So last comment is that, and again, this already happens with normal algorithm, because normal algorithm, like the ones that the example of the bank, let's say it's an algorithm. So if you have a salary below this threshold, then you cannot apply. It's easy. So if you go to the officer in the bank and say, why my mortgage wasn't taken into consideration? Yeah, because you don't earn enough, or because you have 10 children and you have just one salary, whatever. And then you can explain, no, actually this is the situation, so blah blah blah. With AI, that's not the case, because again, you don't know what kind of data were taken into consideration. And I think that the original proposal of the Commission, where they asked to the provider, to the producer, that they actually need to be sure that there is no bias in the data, that the data are high level quality, 100%. For sure, it's a dream, and so I think that was a good move both for the Council and the European Parliament to, let's say, lower a bit and say, okay, you need to do your best still. And that's it.
Thanks so much, Vincenzo. Actually, one of your points makes an excellent introduction to our next question toward Vangelis. You talked about the difficulty understanding and justifying AI models' output. AI models reach sometimes a very high level of complexity that creates limits to the extent we can interpret its decisions. Is it possible, Vangelis, to achieve a balance between the transparency requirements of the data protection regulation and the opacity of certain systems of AI? And mostly I'm talking about deep learning. Thank you so much.
Actually, Vincenzo made a very good analysis on transparency and what can or cannot be expected. Transparency as a whole is something new in the GDPR. We did not have it as such also since 1995 in the directive. So it is something that we came to terms with relatively recently. And still, as also Vincenzo said, there are compliance issues with that, with fulfilling this requirement. Even more so when it comes to AI, because there are general problems with transparency on, so to say, normal software systems, information technology systems. When it comes to AI and the inherent complexity and opacity of these systems, then it becomes even more difficult. And to give you an example, because when we're talking about AI, this is a generic term. This is not something specific. It is as like talking about software in general. It is not discussing a very specific software application, I don't know, a data protection or a word processor or an internet browser where we can achieve perhaps transparency, for example, on an internet browser, because we can understand cookies, how they work, if they're connected with online platforms, behavioral advertising, tagging, tracking, that we can understand because it is a very close environment on an internet browser. But when we're talking in general about AI, then the question would be similar to transparency on software, which is something that cannot be done. Therefore, we need each time to be specific on an ad hoc basis, what type of AI, what type of specific application of AI we are talking about, and then we can discuss transparency and then see if it is at all reachable or not. Because indeed, there are systems that are inherently difficult to understand to non-experts and experts alike. Having said all that, and having discussed the difficulty of attaining transparency, let me please clarify that this is not to say that we should not be looking for it, or that the GDPR in its next version should do away with the word transparency in it. On the contrary, we need to have the legal requirement in the text in order for both us as enforcers or monitoring the law and the industry to comply with it. Because if we go away with the word altogether, then nobody will be looking for it. Having the word in the GDPR text and everybody in this room striving towards it in any way that we can is the best way forward to make sure that it is taken into consideration and that new applications of AI are transparent to the greatest extent and the maximum extent possible. Thanks.
Thank you so much. A quick follow-up questions. We would like to get a little technical here. What about explainable AI and this whole new research field of AI that aims to try exactly to interpret a model's decisions? What can you tell us about that in 1 or 2 minutes, please?
I do not want to enter the discussion of specific AI applications because, quite frankly, every 3 or 4 months we get with new terms. We become familiar with new terms, new technologies. It's deep learning, it's generative, and now it's explainable. It's something new comes along. I would like to take a distance from this discussion, and us as lawyers or regulators or legal scholars, we do not have to follow, to my opinion at least, everybody can argue with that, we do not have to follow so closely each and every new step that information technology, the science of information technology makes. We have to keep a distance and remain on a principle-based approach. The GDPR is an excellent example in this regard because it is a principle-based system. We have and it has survived many technologies in 1995 and the directive, which culminated into the GDPR. Being a principle-based system, having general principles that are then particularized on each separate technology. Therefore, I will use my 2 minutes to reply to you to make certain that everybody in this room at least hears, if not agrees with, the principle-based approach, the rule-based approach, that we have to stick to some principle and retractive approach to technologies and see them from a distance from what they really are, and also see them from a time distance after 6 months, 1 year, 2 years, when perhaps they will have moved out of the spotlight of everyday newsfeed. So thanks.
Thanks so much. Actually, it's very relevant to the next question, what you talked about, which is also towards you. And the question is, how will current regulations on data protection have to evolve to keep up to date with AI innovation? I think you answered partially, but you can take a few minutes to answer the specific question. Thank you.
I think I cannibalized my next question in this in this way. I'm very much in favor of keeping a distance. I'm very much in favor of long-term solutions, and I'm very much happy with the fact that the directive of 1995 has withstood the test of time, has been replaced with the GDPR in 2016 after so many decades. After technology Armageddon happened, the directive of 1995 was not written with the internet developed or in the mind of the legislators, but still it got us until 2018. And I'm very much in favor of that. And also in the e-commerce field, which is not today's discussion, of course, but please consider that the e-commerce directive dates back to the year 2000, has been replaced with the DSA, but still the principles remain. So I'm very much in favor of a principle-based approach that gives us, as the legal and regulatory part of the equation, the social society equation, give us the distance to see things from a neutral and distanced manner in order to reach the optimal solution, both for individuals and also for the industry. And as a last remark, please also keep in mind that the GDPR has on its title has two parts: protection of individuals and free circulation of the data. So we are not in principle opposed to any data processing. We are opposed to valueless data processing. And this, I think, focusing on values and principle is what we should keep doing also in the case of the AI.
Thanks so much for these insights. Vincenzo, next question for you. Many people believe that it is the private sector that is the main driving force of the development of the industry. How will the upcoming AI Act affect the private sector?
Thank you for the question. So first of all, I would like to have all the companies remember that the human needs to stay at the center. So it's not, yeah, but this is the new amazing AI tool. Yes, of course, but what are the consequences? So first of all, think about the consequences, because the humans, people are not a mean to make money, okay, are the end. So if my service, AI service is, let's say, treat human being in a proper way and makes money as well, then it's fine, no problem. But there's no way AI, just for the sake of AI tool, will be, we should stay on the market. So first, as I said, AI could be seen again as other paperwork for sure, because there's a lot for high risk AI. For sure, there will be lots of compliance, very technical and legal. We've seen so far many threats from some international American companies, basically saying, "I know if you approve the AI Act, we will not provide our services in the European market." I mean, that was the case even with the GDPR. So we've seen how it works and how it went. So I don't think it will be the case, because the European market is still so much valuable that I don't see how any company will avoid to be in the European market. So as for the GDPR, we already have two different cases. One is the big companies, so banks, of course, tech companies that are already, especially for example, financial sector, health sector, that are already, open to, are already in the loop of complying with the several sectorial and vertical regulations. So for them, or some of them, I know that are already in the loop, looking at the provisional text of the AI Act. The big problem will be, as always, as usual, for the small medium enterprises, for startups that don't have the legal resources, they don't have the human resources. The problem of the having enough people knowledgeable on these kind of matters, it's a problem. We know we have two Italians here on the panel. We know that all the STEM, so technology, engineering, math universities are not very popular, especially in southern Europe. I mean, and without engineers, without mathematicians, there's no way to understand this kind of technology. So, of course, I'm not saying that a lawyer will lose their job, but we need all this kind of people. So, engineers, lawyers, philosophers, because for companies, there's no way to do any assessment if you don't have a whole team with the various experiences. And then we will have, of course, the ones that will wake up the day before the entry into force. That's for sure. You don't know how many phone calls I received on 24th of May 2018. We need to update the privacy policy. Okay, it's a bit late, but okay. So that will happen. So I really hope that all the European institutions will push for letting everybody knows that you have time. You probably will have two years as a company to comply. Use all these 2 years. And final point will be for sure the authority. Who will be the authority? Because I mean, it's not said that will be the data protection authorities. So far, there will be a new authority where some people from the data protection authority could be involved, but we don't know. And again, you need to have people experienced to be, to enforce this regulation. And imagine even when you have a problem with the authority, you want to appeal, you go to a court, a normal court. I don't know how many of you have been trainee lawyers, if you've ever been to a court, and you have an idea of what kind of judge can judge your case. So, of course, there will be new people, new train, but it's something we really for sure need to deal with. Thank you.
Thanks so much, Vincenzo. Now we move to the last question of today's panel. It's for you, Stefano. How does the EDPS and EU institutions need to adapt to the recent AI technology and regulation advancements in order to keep serving their mission successfully?
Well, first of all, having great trainees like you guys, for sure, and it needs to be said. Well, let me be back serious. I think that the most important aspects in general when talking about technology, but especially in this moment when talking about AI, is to be the first reliable interlocutor that can be consulted, that can be, let me say, easily spoken with when you need to understand how to comply correctly. So not being the adversary in the field, but being the advisor, a competent and reliable advisor. And how to do this? Good question. On the question. My idea is that we need to follow some examples that are great and are already around Europe, and is the ability to be the first one to try, use, dig inside specific applications, trying how the engine works, going below the cockpit and seeing how things can work, making experiments, looking at the best in class and talking to them, technically speaking, in order to be able to inform all the other more legal aspects of our work. Because I'm sure about this, knowing more about the technological functioning of those applications will make all the legal argument that we will have more credible and more solid. So I think this is absolutely, to me at least, the first way that we need to get prepared. The second one is maybe to move from a very an understandable reactive approach that the Data Protection Authority tends to have nowadays and in the past, because of the evolution that society first had to do on these matters, to a more proactive role. What does this mean? it can be done in many ways also. But for sure, it's one of those ways can be to start monitoring weak signals of things that might come out in the fringes of our society or the technological world, and start understanding how to interact with those to diminish risk, to contain and minimize risk, but also to nudge the positive applications of those technologies, because we need, I think, also to have this part of the narrative, the positive one. Think about ChatGPT. ChatGPT, someone called it a black swan. It's not at all a black swan. If you look at, I remember I was looking at OpenAI back in 2015 or 16, something like this, and I was literally saying, wow, what those guys are doing, general AI. Wow. So for once, for those that are like Spiros, very deep in the AI domain, well, maybe the timing could have been difficult to predict, but surely not what would have been out of that model and that works. So on this side is, for example, what we started doing 3 years ago at the EDPS with the Texonar project. It's somehow something that is toward this direction, scanning the horizon of technological developments to be able to understand which are the at least 5 most important technologies that we need to monitor today in order to be able to know more and act proactively towards the future that we have in front of us. Yes, those are the 2 ways, and thank you, Spiros, again for the question.
Thank you so much, all the speakers, for their answers. But this is the end of the panel discussion, but we are far from over. Right now, we're going to move on to the Q&A session. People that are on site can do their questions, direct their questions toward our speakers, and those of you that are online can write them on the chat. And of course, we are still expecting our second keynote speaker to connect at any moment. So thank you.
Hello, everyone. My name is Renata. I'm a trainee from the EDPB, and I will provide support with the Q&A session. I will take the question from online. We already have 2, but we will proceed by taking 1 online, and if we have a question from people here present. The question is a bit broad. It is addressed to the representative of the European Data Protection Board and EDPS. We have high-level experts here. Also, Isabel Vereken, the head of the EDPB, will do the keynote, but feel free to intervene. The question was the impact that, as protectors of the data protection at both national and EU level, was the impact that you had on the AI Act, if it's something that you were able to contribute on, if you want to elaborate on that. Thank you.
This is one of the points. Well, sorry, Isabel, I start just for the order of the table. This was one of the big question that Leonardo said before, that we have the DPS. It's something that we still need to explore. We can start thinking how this might work, and for sure there will be many overlappings in my mind for the work that we do, at least. In the sense that, you have many AI systems that process personal data, but you have also many AI systems that do not process personal data, but you have also the majority that do both things. So, it becomes crucial to understand how to apply rules that are similar, but not exactly the same, to a system that is working with both data as inputs. And in general, also, the big question is the one that Vincenzo was speaking before: who will be the competent authority? To whom are we talking when we need to demonstrate something and be accountable with? And I have a special thinking about the financial sector, that I know in the AI has specific provisions with specific regulators that need to be considered in the loop. The financial sector is, I think, the most regulated sector ever, has to comply with 1 million diverse and conflicting legislation, plus the AI Act as of tomorrow. But Isabel, to you.
Thank you, Stefano. Maybe to recall that indeed the AI Act has an important impact in relation with data protection, and for that reason, we have been asked, the EDPS and the EDPB, to contribute and to provide an opinion on the piece of legislation. And so we adopted a joint opinion where we provided some position that maybe I will explain a bit later. And these were taken into account by the co-legislator, in particular by the Parliament, into the negotiations. So this is indeed how we do contribute to the work of the development of this piece of legislation. Thank you.
Thank you so much. Are there questions from the public? Thank you. Please.
Can you hear me? Great, thank you. I just wanted to go back to the introduction, I think, where the panelists discussed the fact that the use of, for example, biometric AI is for now not very used in Europe, I think, which is better for us. And it was distinguished the fact that in China, for example, there's social scoring based on facial recognition in the streets, etc. So I just wanted to go back on this point because I think that in France, for example, a law just passed and allowed the fact that during the Olympic Games there could be facial recognition. And there's another law under examination in the French Parliament to allow as experiment during 3 years, in generally speaking, and not only for the Olympics, this facial recognition. And of course, one of the key elements is terror attacks risks and security defense. So I just wanted to ask any of you about this balance of rights and generally speaking, how would you approach this? And we can see often that once you have a small opening for an exception, then it always gets more used and more used. So do you have any thoughts on this?
Can you please tell if you want your name and the institution?
Yes, Marlene Pizzetta, Olaf Anti-Fraud Office.
Thank you so much, please.
I can take this one. So I haven't said that in Europe we are safe, because we are not. Let's say we are safer because we have some regulations. But I can tell you that even just, with the GDPR, which is, it's there. I can tell you that in Italy, but not just in Italy, police and several times started just to use facial recognition technologies without neither notifying to the Italian Garante, the Italian DPA, neither without providing with the DPIA, Data Protection Impact Assessment, just like that. Say, what? I mean, that's what any student of that have just read once the GDPR by mistake say, no, but this is not possible. And still, police did it. Of course, then the Italian DPA intervened and, and then all this processing was stopped. But what I mean is that I'm not saying that there are bad people in the authorities, in the police, in the law enforcement authorities. What I mean is that without the proper training, even if you have a law, this risk will be there. The problem with the first version of the article, the first version, is still the official version of Article 5 in the proposal of the Commission, is that yes, it's unacceptable to have a remote live biometric identification, unless. So there is a huge exception for law enforcement authorities, even for crimes that are, it's not terrorists. So some of the crimes that are listed are, 3-year sentence. So 3 years is, you don't need, you have not killed someone. 3 years, perhaps is a, I'm not saying that you can do it, but there are some crimes that are not so relevant and in this kind of balancing test. So that's why I'm hopeful that the European Parliament could push in this direction. I don't want to monopolize, so I'm stopping here. And then just a thing. I think that Stefan was relying on the Olympic when you talked about France, no?
No, I was speaking about the carnival festivity.
Okay, then just one quick word on the Olympics that you mentioned, the law in France. So in that case, the final law was something that was in a way concerned, was not concerned, was written, let's say, together with the CNIL, the French DPA. Of course, I can be mistaken, but from what I read. And then basically, we're not talking here about facial recognition, but about, let's say, you will be able to find, I don't know, a red bag, okay, in the crowd. So you can identify objects or particular weird way to act. Okay, so it's not about facial recognition. So from one side, say, okay, this is better because we're not talking about Vincenzo Tiani is entering right now in a square, but we shouldn't just say that, okay, then we are completely fine. Because again, you can find a way through this through this new law to, in a way, discriminate people. Because you will always find a way to identify a certain group of people using certain categories, certain information, without even using the the color of your color, your face or whatever. So I'm glad that the CNIL was in the loop, but we should still have an eye on it. Thanks.
Thank you so much, Vincenzo, and all of you for your questions. We will suspend now the Q&A session as the next speaker has connected. We will continue after. Please send your questions online. Thank you. Spiros.
Hello. It is very pleasant for us to welcome an old acquaintance of the EDPS, Brando Benifei. I say this because Brando has also honored last year's trainees with his participation in the podcast in July. Brando has been a member of the European Parliament since 2014. He has served on the Committee on the Internal Market and Consumer Protection since 2020, in the Special Committee on Artificial Intelligence in a Digital Age, where he serves as the Parliament's lead rapporteur on the AI Act. Furthermore, he is part of the delegation to the Conference on the Future of Europe of the European Parliament. Brando, thank you so much for being here with us. The floor is yours.
Hi, can you see me? Yes.
Yes.
Okay.
Now we can, yes.
Yeah. Okay. So I am on a train. Unfortunately, I had to change some scheduling. So I hope you will be able to hear me and that the connection will not be lost. So I will try to be very brief and direct to give you some inputs that can stay there in any case, even if maybe I will not be able to stay a long time. But thank you for inviting me. And I saw when I connected that it was Vincenzo Tiani speaking that I greet. It's clear that the topic of data protection and the role of data for the functioning of AI is crucial. We have been working on this topic in various aspects in dealing with this AI Act. For sure, it's important to note that we aligned the regulation much more than the original text with with the text that the Parliament has approved and that now will be negotiated with the Council to the GDPR. We have aligned the text to be GDPR proof and aligned with this approach because we think we do not need a separate legal basis and a different way of processing of data when we deal with AI. There are some small areas of differentiation, but really limited. And for example, we have an exception when dealing with data, with sensitive data for correcting biases. But in general, this is the alignment. Data in general is crucial to the AI Act. In fact, a lot of the requirements for high-risk AI to be able to enter the European market are centered around the management of data, the appropriateness of data that is being used, and the respect of the rules around data, and some of the choices that we have taken, for example, of proposing a further ban, a stronger ban on surveillance through biometric identification in public spaces in real time. They are linked to worries about privacy. And also, this can be said when we talk about the issues related to social scoring, but also to predictive policing to some extent. And for sure, when we also look at the issue of emotion recognition in workplaces and in schools, that we also are proposing to ban. So there is a lot of attention to this, and to be frank, all over the world, the debate is growing around these topics. When we look at the discussions around the risk mitigation of AI, also in other parts of the world, the issue of data protection is always quite central. So my main message is that the topics you work on and the role, let me say, of data specialists, of privacy professionals, and so the data protection authorities at national level, but then also the EDPS and the EDPB will be crucial in building also the governance and enforcement of the AI Act. If we look at the idea of the AI board that we are turning into an AI office, and the role of the national supervisory authorities. So I think I will limit myself to this, because I know that the connection is not going to last very long, but maybe if you have one or two questions for me, I can try to briefly answer. And thanks for this opportunity to just give a few inputs, and I hope we can have a more easy meeting in another occasion. Thank you.
Thank you so much. Actually, we have a question from online that could be maybe something that you would like to react to. Basically, the question is, what are the experts' view on the risk-based approach, as someone may argue that fundamental rights were not considered in an appropriate way. So, of course, in line with our conference of data protection and AI, it would be interesting to know your reaction to this or your opinion. Thank you. I think we lost you. Okay, it's okay. Maybe some other experts would like to react to the same questions, either here in presence or online. Feel free to take the floor. Of course. So basically, if I appropriately understood, the person was wondering your expert's point of view on the risk-based approach of the AI, as someone may argue that fundamental rights were not, of course, to data protection, were not appropriately considered in the approach, let's say. Thank you.
Yes, I agree. And that's why I'm glad that the European Parliament, approved in their final version, the Article 29A. So far, yeah, the risk-based approach, I think it's a good approach. I think that the Act is more written differently from perhaps GDPR. The Act is more addressed to companies than to people. GDPR, I think it takes more into consideration the data subject, since we are talking about its personal data. AI, it's not just about personal data, as Stefano said. The problem with the fundamental rights impact assessment, of course, on paper, it works perfectly. Why not having a fundamental rights impact assessment? It will not be easy, again, to do it. So this will be the next challenge. If I can do a little promotion actually, so with the Brussels Privacy Hub, I'm a PhD researcher at the Brussels Privacy Hub as well within VUB, so the same university here in Brussels of Vagelis. We are willing to organize an event on fundamental rights impact assessment. It should be in October, so if you want to look our Twitter, LinkedIn page, and we will. Why I'm saying that, not just for the sake of publicity, is that we need this kind of discussion. We need experts. We will have academic, we will have European institutions, we will have the council to try to understand why this kind of these articles should stay and how actually it could be implemented. I'm sure that I think that even the data protection impact assessment at the beginning of the discussion at the European institution perhaps wasn't quite clear for the stakeholders, but then we, in a way, I mean, it's still used and it works. So sometimes it's good to not have, let's say, a proper checklist and give the companies, let's say, just more freedom. On the other side, sometimes the companies just need, please tell me exactly what I need to do because I don't know, I don't want to think too much. Just give me the homework, I will do it. So it's, let's see if it will survive the trilogue.
Thank you so much. If other experts don't want to react, I think we have some questions from the public. In the first row, someone, and also others. So please, thank you.
Thank you. Ivan Dragoș, Grow, A2. So from the very beginning, I would like to thank Vincenzo because it brought about the discussion on SMEs, and I really like that. Coming back to my question, during the discussion, I noticed that privacy indeed continues to be an essential principle of constructing our EU framework based on technology. But at the same time, also during the discussion and from our general experience, we noticed that AI, in order to function, in order to better our lives, to make it easier, to give coherent responses, it needs some training data, it needs interaction, it needs to process this type of information. And I was really curious about how we should make this comparison, how we should construct this equilibrium, also legally speaking, because at the base I'm a lawyer, so I'm really curious of how I can balance the two, privacy and the need to use the data, and also where we should draw the line. Thank you.
Should we collect more questions? Yeah. Would that work for you? Okay, in the second row, please.
Does this work? Yes. So I actually wanted to ask about a specific scenario, a real life case, and to kind of ask about your opinions on what you think about this in the framework of the GDPR, but also the AI Act that's being drafted. So I'm sure you've heard about the case of ChatGPT being or maybe being sued by one of the mayors in Australia, where it was false information about him, of him participating in bribery. I think this also ties into a bigger concern currently in a discussion about AI and misinformation. But I think, at least just very quickly, I'm thinking in the framework of GDPR, there's also the principle of data rectification. So what kind of approaches would you take with this specific example in the context of the GDPR and the AI Act?
We will take one more question. Please take the floor.
Can you hear me? Hi, I'm Lorraine from DG Connect. You've been mentioning that we are going to need experts and people like engineers and lawyers that understand the background of IA to implement and make enterprise compliant. My question is, do you think it would be interesting to regulate professions such like DPOs or cybersecurity officers or code auditors in enterprise to make sure that they understand what's going on and we make sure also they're able to comply? Or is it going to be it's going to become a critic saying, hey, Europeans regulate everything? So the question is, can we create a regulated profession for DPOs or cybersecurity officers?
please react.
Let me try to address those other million-dollar questions. I think that matching the first two, we are exactly what you mentioned before. The ChatGPT case in front of the Italian data protection authorities that then triggered the task force at the EDPB, it's starting to create a lot of, let me call it legal certainty, a bit more of legal certainty in how to use data for the diverse, in the diverse phase of the AI flow, starting from the training part. It's a very complex question because yes, you need to collect data, you need to collect a lot of data to train algorithm and to build your model, and you need to find the proper legal ground following the GDPR. The first, maybe Isabel, correct me if I'm wrong, but the first decision taken by the Italian Data Protection Authority was to ground this data use, this data processing operation on the legitimate interest. And then to see the following and the further processing of personal data, how can be based on which legal base. For sure, this is a start because there's a lot of complexity in order to understand how to apply the GDPR rules to especially to the training phase of the GDPR. There are also other solutions that might be even technical. I have in mind, for example, using synthesized data. Synthetic data are data created by a generative AI process that, starting from an original dataset that contains personal data, creates a new dataset that replicate the statistical properties, but without the real name and surname and details of every person involved inside the second output datasets. So this can be a solution, but it's very costly to use, very expensive to have this kind of solution. And yes, I think it's like a work in progress, no, and on this field. Maybe just a point to the third question about regulate professions. Well, in Italy, I remember when the GDPR came out, there was like Vincenzo was continuously addressed by customer and clients saying, can we revise the privacy policy on the 24th of May 2018? I had the same question saying, hey, but you want to be a DPO? Have you been certified? You cannot be a DPO if you're not certified. Really? Yes, a lot of them. Well, no, it's all very interesting to have, a step more on the certification, on creating a small circle of a DPO that share ideas and solutions and so on. But frankly speaking, I think that the DPO example worked quite well. It's always difficult to find where stands the balance between the regulation and the market forces. But somehow it's good to have this kind of people mandated by a law in the organization. It's also good to leave to the private markets and the market forces the possibility to shape those figures coherently with what they need in their specific situation. I know there are many proposals also in this sense, but at least from my experience, this is what I have in mind. And thank you for the question, sir. Very interesting.
Just following up on the last point, both the AI Act and the GDPR says that, yeah, you want, for the ones that are not really into DPO stuff, no certification of being a DPO is required by the law. So that's why, and the problem is, not the problem, but GDPR and the Act both ask that the people that are involved in data protection for DPO and the AI for the AI Act need to be knowledgeable, need to be expert. They're not saying, the text doesn't say you need to, having studied in the top university in Cambridge or whatever. But of course, you need to, in the accountability looking at the accountability principle, you need to prove that, okay, I studied law, I specialize in data protection, I did this and that, I did this certification, and that's okay. I can tell you that, again, in the panic of 24th of May, when you needed to, send the DPA, the talent DPA, or the, as a company, the name of the DPO, I can tell you that there were companies, not the big ones, but that say, what do you do? I'm a secretary. Okay, now you are the DPO. That was the case. Of course, then the name, I hope it was changed, but that's how it started. So I think, again, as Stefan, that the market will regulate, and that we don't need certifications like provided by the law, but for sure they will help.
Thank you so much for your answers. Since I'm not seeing our experts online, feel free, Vangelis and Leonardo, to take the floor if you would like to add something to these questions and also provide your point of view.
Okay. Actually, Renata, I'm taking advantage of my online status to hide from these difficult questions and let my colleagues reply. But no, I'm kidding, of course. This has been very interesting, and I'm following up closely, and I'm happy with the discussion and the replies. I think the only thing that was not perhaps addressed, but maybe understood wrong, was the question about the Australian mayor or something and the delisting. In that case, I was not aware of the case of this mayor suing ChatGPT because of the Amazon or whatever claims. But again, in this case, it is always useful to go back to what is already in effect. And we do have a process in Europe, the delisting and the right to be forgotten and all this Google Spain decision that the way I hear the facts could be dealt with. Because again, AI is based on material found on the internet and elsewhere. Consequently, I would imagine that these two rights apply there as well. So this is also a useful example to draw your attention at always looking back to what is already in place and not considering its new problem as something entirely new and unprecedented. Because most likely, over the years that have been built of intensive data protection application in Europe, most likely there is already an answer out there that is either ready to be used or needs partial amendments, but not an entirely new discussion. And the same applies to the last question on regulated professions. Again, flashback back in the 60s and the 70s. So even before we had data protection, there was a discussion because then it was that computers and software emerged, and this is what led to data protection anyway. So there was a discussion whether we should regulate information technology professionals. And maybe they should form an organization, an association like lawyers or doctors, etc. And it was an ongoing discussion. Same as with the discussion whether we should give a new right to software. We did not. We gave it copyright and patents, and we did not also regulate IT professionals into a new profession. And as was said also by my previous speaker, the DPOs are not regulated professions. It's not a regulated profession. There is no certification and there is no association in the way that a lawyer or the medical profession is. Therefore, I think this discussion has been made and it has been replied in the negative. Regulated professions, especially an entirely new regulated profession, and especially in such dynamic fields of the economy and science as information technology, would only, I think, create problems. Yeah, and as said, I'm hiding behind my online status, but following up very closely this extremely interesting discussion.
Thank you so much. Would you like Leonardo to add something else?
Thank you very much. Very briefly, before we give the floor to Isabel, who will have a lot of interesting things to say. I agree with most of what we have said, but I think one thing that I'm not sure has been properly said is that we need to approach the regulation and supervision of AI with a different mindset. If you look at what has happened with the regulation and the supervision of data protection, you have seen that in some cases, or in many cases, up to you to judge, this has not led to real changes in the way that big technological companies process personal data. Even in cases where there's been enforcement, it has not been translated into any meaningful changes in the way that these companies have been operated. I believe this, in the world of AI, will not be sustainable. I think big technological corporations need to go through a profound change in the mindset, in the way they approach respect of fundamental rights and the dignity of individuals. Otherwise, the system will not be sustainable. At the same time, I think data protection authorities need to be very pragmatic and open-minded to embrace this technology, not to oppose this technology that has huge beneficial potentials for individuals. So I'm calling for a new deal here, where corporations take these issues much more seriously and data protection authorities become a little bit more constructive in the way that the relation with technology is deployed, and how we can get untap the potential of new technologies for the future. Thank you.
Thank you. Unfortunately, due to time constraints, we will have to close now the Q&A session. Thank you so much for contributing to it. Spiros, the floor is yours.
Thanks so much. We're moving towards the closing remarks by Isabel Vereken, Head of Secretariat of the European Data Protection Board. Isabel has a vast experience in the private and public sector. She's a lead expert and has overseen the establishment of the EDPB, and she has assisted with the GDPR negotiations. Isabel, thank you, and the floor is yours.
Thank you very much. I would like to thank also the panelists and the participants to this event. Special thanks to this amazing team of EDPB, EDPS trainee who successfully managed to organize this great event on a very current and complex topic, very interesting. The use of AI will have a deep impact in our society. It's already even the case. It has and will have many applications with a large number of sectors. We already heard the sector, financial sector, police, education, health. You said finance is highly regulated as well, health. You will go to your doctor, and you will not be the only one making a decision or searching for your for a solution to cure you, because there will be a system that will analyze and help with the decision-making of doctors. So that really has impact, I would say, at the top level of the educated people. So because those people are making very long studies, but now we consider that machine can be better than those people, even if they're making dozens of years of studies. The AI will automate many tasks performed by humans, generate images, videos, text, code, chatbots, and general solutions. And as it was said by Brando, data is crucial for AI, because to be able to make AI, you need to collect and to use a lot of data. And Vincenzo said that that AI is under GDPR as well. This is, of course, the case, and we all agree, I think, on that. There are many aspects on this. One has been raised by Stefano, the Article 22, like on automated decision-making, that you need to have a right to know the logic and also to have a human intervention. But there's not always also automated decision. It can be also use of AI without that. The AI raise a lot of fundamental right questions, and which depends on the type of application that was raised by Evangelis, because depending on the application, you will have different analyses that will have to be performed. And this is also why I think the approach by the risk was taken in the AI Act. I will make some reference to questions that will be, I would say, impact on AI. First, about the information about the system, how the system operates, how the outcome was generated, what model has been used. Is it a correct result? We know that there are a lot of hallucinated information that are commonly produced. There are also issues relating to fairness, possible bias, discrimination. We need to use data that are accurate, but you said that you believe that it's even possible to have a high set of data that will be fully accurate. In fact, AI is a kind of magnified lines of bias of human, but it's just that because it's made by a machine, we think that this will be real and more objective, which is totally, of course, not the case. And as Stefano said, the machine is making error. This is obvious. The same for simple biometric system with your fingerprint. Sometimes it doesn't work, false match. This is inherent of the system. Then, when decisions are made and affect individuals, they will have to have a right to understand how it was taken and how to oppose to the decision, to understand the logic and to have a human intervention. But it's true that the system will be more and more complex, how to explain the algorithm. Because AI will make a connection that just a simple human being will not be able to even understand from where those connections are made. Look at the example that was made by Vincenzo about the mortgage and the fact that maybe you don't have enough revenue, then you don't have your credits, your mortgage at the bank. But the reality is that they are making correlation that you would not even understand, that maybe you are living in a particular street, that there is a trend, that people do not reimburse your bank, and then you would consider yourself, but why? But because the machine is making some links that you can not even understand on the basis of statistics. Then there is also a possibility of impact on other rights, fundamental rights, and also on the society. We are touching here the ethical aspects that needs to be considered. Looking at this example of real-time remote biometric identification in public space, that will, of course, limit capacity of people to freely meet, think, engage in the society. That's an obvious example. So that's why we heard Vincenzo welcoming the fundamental right impact assessment proposal that was made by the Parliament. And then the technology needs to be secured, of course, because is it reliable? Has it been subject to an attack? These are important questions to answer. Now, I would like to talk about those prohibited AI systems, because this is, of course, as you said, a very important point in the AI Act. This was a point that was strongly made by the EDPS and the EDPB to call for a general ban of a remote biometric identification system in public accessible space, whether it will be real-time or not. And this is a very important element, because if you look on those kind of processes, there are questions relating to the legal basis, questions relating to proportionality, transparency, how to inform the people in advance, exercise of rights. The proportionality is really key here, because it's about monitoring the entire society to eventually find 1 or 2 persons that are creating troubles, or to find some individuals. If you are interested by those questions of proportionality, you can look also on the very old case at the European Court of Justice with the Data Retention Directive and the Digital Rights Ireland case. I think there are a lot of learning from those cases that can be reused here. Stefano, you said that it's a problem for you to have the feeling to be always monitored, but at the same time, so continuously. But at the same time, we see that people are getting used to that, because Vincenzo said he's going to his parents to check what is the reality and what should be the normal, I would say, feeling after being monitored. So it's true that we need to be vigilant, and we have young users and which are just under the use to be always under a camera and to share everything online, etc. But it's the problem is about how the use will be made. And then I will make a reference, because those systems are just available, not only to the police. They are just simply available and free of access, not so free, but I mean for like a few hundreds of euros, you can buy those kind of systems. And in the New York Times, like a few days ago, 28th of June, was a very interesting article on facial recognition technologies, and not so far away because we're not talking about China, but we're talking about New York, where it was said that it was those systems were so easily accessible that MSG Entertainment, the owner of Madison Square Garden and Radio City Music Hall, has used automated facial recognition system to refuse entry to lawyers whose firm has sued the company. So you want to see a concert, you want to see a soccer game, but no, you cannot because maybe you are a lawyer on the right, on the opposite side, and then you have your prohibition to just have some free time with your family to go there. So that's very important to realize that it was also said by someone of the public, I think, in the Q&A, that when there is a technology, then the use is made for other purposes. That's a basic in privacy. The EDPB was also in favor of additional types of ban, the social scoring by private entities that was in fact endorsed by all, I think, the co-legislator. The use of biometric to infer emotions, we see that there the Parliament will prevent the use in law enforcement, border management, workplace, education institutions. I was talking to one of my colleagues earlier today that told me that some years ago already in Italy, because this is an Italian day, because I'm really surrounded by Italian people. They are very good. We are on the top on the summer, so...
You're not in Florence, but...
no, not in Florence, yes. But yes, that maybe some employers would like to look at the place where you drink your coffee and just to look at your emotions, if you're happy or not at the workplace, and to gather information about the employees. When the technology makes it possible, why not? Then there is also the call for prohibition of biometric categorization system on the basis of sensitive data. So in practice, for instance, to imagine that on the basis of your color of skin or whatever, then there will be different trend interpretation in the use of facial recognition. So based on sensitive data. And then the scrapping data online, so collecting all the data online that was used for law enforcement, it was also raised. AI system must comply with the law and be aligned with ethical standards. We need safeguards, human oversight, education. And we made reference to the need of lawyers, philosophers, engineers. Also at the court, need to be educated, but that's normal. I mean, privacy is moving also to technology. These fields are very closely related, and so that's why it's important to keep educated even ourselves. And there are already some actions for the DPOs to learn about AI. There are some available tools that are, and certification, even if it's not mandatory, they are already available. And I've seen a few days ago that the CEDPO, that's a pan-European association of DPO, who made Q&A on the use of AI and try to train themselves, the DPO in different organizations, including those ones that are a bit smaller and doesn't have the capacity to make all the research. So the AI Act builds on a risk-based approach, which is welcome. As Leo was saying earlier, we need to be flexible enough to have some innovation, but it needs to be a clear framework and strong enforcement. A lot of application of AI will process personal data and then GDPR apply, and it's essential to have the DPAs having a central role in the regulation of AI. The EDPB is closely following this subject matter. We made some specific guidelines, some facial recognition technology in law enforcement, but also this EDPS joint opinion on the AI Act, looking also on AI liability in a different letter. The monitoring of this technology is a strategic priority for the EDPB, as well for the EDPS, I'm sure, as well for many data protection authorities. We also took part in the G7 statement on generative AI to clarify also that privacy was applicable and to underline the risk. And then the reference to this ChatGPT task force, because indeed, after the decision that was taken by the Italian authority, it was an immediate temporary limitation and banning on the use of ChatGPT in Italy for different reasons, problem of information, legal basis, exercise of rights, and protection of minors, then indeed there were already some different actions. In fact, even different complaints in different member states. I don't want to be too complex to explain the data protection framework, but normally when a subject matter is cross-border, there is a kind of cooperation, but in this case, there is no main establishment in Europe, so all the authorities are competent and eventually can deal with their complaint. And so at the EDPB level, we decided to have a task force to try to coordinate and to have, to foster cooperation on those enforcement actions. Then key to have then effective supervision. It's then really important for member states to ensure that there will be resources for data protection authorities. Today we have a lot of lawyers in data protection authorities. We need to have also more IT technologists, and to be able to recruit and IT technologists, they cost a lot on the market. So today it's already difficult to have a data protection lawyer in a DPA because the private market is quite demanding, and there is a lot of experts in this field. So if you are looking for a field which is, you will have for sure job in the future, this is a good example. But then for looking for IT specialists, that's also very important, because we need to monitor those new technologies and also to accompany, like in sandboxes, the development of AI. To conclude, it goes without saying that AI brings numerous benefits to our society. There are a lot of risks that are real and can have a negative impact to our society. We need to have, as Leo said, enforcement that will imply change in practice, but that's difficult in practice to regulate the society and to have a real impact because when the technology has been developed and made available, then this is creating trouble. So that's why also it's interesting here to have some ban from the origin in the AI Act. And we need to take action from the beginning. All those actions that we're taking in Europe, development of the AI Act, the application of the GDPR with the ChatGPT, the enforcement action, the creation of guidelines also by the EDPB, all these contribute to a legal certainty. This is a foundation for a level playing field, for organization, for the protection of individuals, robust enforcement by authorities. So that's how I think we are looking for having this Brussels effect, because it's important in Europe, I think, to try to regulate and to, at the same time, to enable innovation, but in a way that will be respectful of fundamental value. I would like to thank again the trainees for having chosen this excellent topic and for having offered me the possibility to take part in this conference. Thank you very much.
Thank you so much, Isabel. I think you covered a lot of aspects and examples that needed to be addressed in order to complete the context of the whole discussion. Unfortunately, this will be the end of the event. I hope this conference has been constructive and informative for each and every one of you. I think we held a very enlightening and interesting discussion. A huge thank you to all the speakers who took time from their personal schedules to be here with us. Also, thanks to all the audience that either online or on site who followed us on this discussion. And I would also like to thank the EDPS employees that helped us and provided their expertise for all of this to happen. For those of you that haven't had enough, we can unofficially continue the discussion and the interaction at the European Parliament canteen. Thank you so much.